Good afternoon, everyone. We're just waiting for the parties to join and then we can get started. So we will get started in a few minutes.
Good afternoon, Your Honor.
Good afternoon, Mr. Jacobs. And Mr. Hartnett, good afternoon. All right, we are here because of some information from Mr. Jacobs about the health of his client. What's the situation?
Will this hearing be impounded, Your Honor? Because I'll be revealing personal health information. I don't want to get into a problem with HIPAA violations.
I'm not at all convinced that it applies, but I haven't looked at the issue myself. So I'll tell you what, we'll impound it temporarily until I find out whether that is an obstacle, this disclosure. You have a view on that, Mr. Hartnett, one way or the other?
I don't, I mean, I don't know why it would necessarily violate HIPAA, but I don't have any real knowledge.
I mean, we're in a position, I don't know. Well, let me ask you, without divulging the particular health issue yet, are we here because you're going to be requesting a continuance of the hearing?
Yes, Your Honor.
Okay. So at least I know the contours of what's at issue here. So I think the best way to proceed, because we have a time issue, is to temporarily impound. And if I learned to the contrary that there's no HIPAA issue, I'll give you a chance to be heard on that before it's unimpounded, if that's appropriate.
Thank you, Your Honor.
All right. So what's the situation?
Wait, sorry, Judge Fishman, just
yeah.
to interrupt right now.
You didn't start it, so hang on.
No,
Sorry.
no, it's just right now the hearing is open to the public, so there are attendees. Would you like us to send another Zoom link so we can proceed and decide whether we should reconvene?
Well, the only thing of possible protection is a specific health issue, right, Mr. Jacobs?
That is correct, Your Honor. Of two witnesses.
I mean, because I would assume that all the rest of what we're talking about is, yes, let's do that. But I want to have to be able to go back on public after I get the potentially protected medical information. I want the rest of this to be open and available to the public.
Yes, I will send the parties and you, Judge Fishman, a separate link.
Okay.
Thank you.
So did you need to sort of put on the record what this is, Lizzie?
Yes, sorry. So this is a status conference in the matter of William Castro. Right now, this proceeding is open to the public and we are convening remotely over Zoom, and this status conference is being recorded. I have another Zoom link that I'll send you all. In the meantime, I think we may have to close this Zoom session and we will resume shortly after things are resolved.
All right, let's go to the closed session so we don't make a mistake, and then we'll come back on a public session.
All right. Thank you.
So go find your new link.
Hi, Judge Fishman, can you hear?
Yes, I can. Thank you.
Great, thank you. All right, so everyone's here. Good afternoon, everyone. Today is Wednesday, November 5th, 2025. The time is 1:34 p.m. And this is a status conference in the matter of William Castro before the Massachusetts Peace Officer Standards and Training Commission. This proceeding is open to the public. We are convened remotely over Zoom, and this status conference is being recorded. This matter is now before Judge Fishman.
All right. This status conference was scheduled to address a concern about continuing with the adjudicatory hearing in this case scheduled for this Thursday and Friday and beyond, if necessary. And it came to our attention through Mr. Castro's counsel that he is ill and unable to participate in the proceeding. We had a closed session so that I could obtain information about Mr. Castro's medical condition, which had really no need to be part of the public record, as well as the apparent health issue related to another witness in this matter. After hearing from counsel, I have instructed Mr. Jacobs to contact his client, to instruct his client that we needed to have confirmation from a healthcare provider regarding his current medical condition. My concern and need for verification is based principally on the fact that a lot of effort has gone into being able to schedule this matter and a lot of time has taken to get us here to this point, but primarily because of the availability of many public employee witnesses in this case and scheduling their appearance. And again, the need to have Mr. Castro be able to participate and assist his attorney in this matter. So rather than spend a lot of time reviewing that, we'll continue this hearing till a later moment, until as soon as Mr. Jacobs reports to us that he's had an opportunity to talk to his client and see what can be done about fulfilling the requirement of obtaining confirmation of his condition. Any questions from anybody? Apparently not. Okay. So we'll continue this matter after Mr. Jacobs contacts us. We'll reschedule us getting back together so I can make a final determination about the schedule. Thank you.
Understood, Your Honor. Thank you.
Thank you.
Thank you. Good afternoon, everyone. We're just waiting for the parties to join, and then we can get started in the status conference. All right, good afternoon. I believe everyone is here, so I think we're good to get started. Today is Wednesday, November 5th, 2025. The time is 2:35 p.m. and this is a status conference in the matter of William Castro before the Massachusetts Peace Officer Standards and Training Commission. This proceeding is open to the public. We are convened remotely over Zoom, and the status conference is being recorded, and this matter is now before Judge Fishman.
All right, counsel, just if you'd confirm your appearances, please.
Good afternoon, Your Honor. Walter Jacobs for the respondent, William Castro.
No, Timothy Hartnett on behalf of the commission.
All right. Where are we, Mr. Jacobs?
Without going into specifics, I believe it has been confirmed. I can go into detail offline, but I believe it is confirmed. And communication has been had so that we can satisfy Your Honor's request.
Well,
I can provide detail in a private setting.
well, without talking about any specific medical issue, is there confirmation from a medical care provider?
That my understanding is there is diagnosis and treatment
Where's your understanding come from?
from Mr. Castro.
So how do I get confirmation of that?
I've asked that a note be provided, but that has not gotten to me yet because I made that request just briefly. And obviously, if the office is in the middle of afternoon hours, that's going to take a little bit of time to get. But I've asked for that to be provided. My understanding is that
in the first instance, I'd be satisfied if somebody conveyed that to you orally.
if you want me to call the provider, the problem is I'll have to get release forms signed. The provider is not at liberty to talk to me because it'll be violating the ethics and the Board of Medicine rules. I would have to have the office send a release to Mr. Castro, have Mr. Castro sign it, send it back to the office, and then talk to the office, assuming that the provider is available to take my call in the middle of his office hours. I will do that if that's.
Well, what we have now is it sort of leaves us in the same position we were. I appreciate the fact that you followed through and that apparently Mr. Castro has as well, but all I have now, of course, is information from Mr. Castro. And that's all the information you have is from Mr. Castro. So I'm just trying to figure out the most efficient way in view of the fact that a lot of people are standing by to confirm it. That's all.
I will have proof when his wife it goes to the pharmacy as soon as she's gotten out of work to get it. It had to take time to get the authorization, and then apparently it took time for whoever in the office actually phones in or writes in or faxes in or emails in or electronically sends in the prescription. That's all been done. So now that's being prepared at the pharmacy. I will have proof of that from the pharmacy once that's been picked up. That all takes a certain amount of time. I can get information. I've asked him to get me written confirmation from the provider's office. That is in the process of being gotten. I have not spoken to the provider. That is correct, because he will not speak to me, I'm sure, unless I get releases first, and that takes time. And because we have these people waiting, and I don't want them going into Boston on a wild goose chase, I didn't want to wait another hour or two to get these pieces of paper. I've asked for them to be provided so I can subsequently submit them to you, pharmacy proof, etc. But I don't have that.
Let me ask you, I understand what you're saying. Let me ask you this simply, without again telling me the specifics, is it, are you advised that it's been confirmed what was, you thought what his medical issue was?
That is my understanding, that that diagnosis was made. Okay. Now, my client has made it very clear to me, he is very upset at the implication that was made in the private setting by the division. He will appear, but then I have made it very clear I will withdraw, because I'm not going to put myself, as I had indicated in the other session. I think that would be something that would be very inappropriate for me to do. And okay. I say that very respectfully. I'm trying to be extremely respectful. He is not happy at the implication that was communicated, and he will appear if he's required to do so. He will be there, but I will not be able to be there. I cannot do it.
Well, if, as he says, it turns out that he has been diagnosed as we talked about, I'm not going to require anybody to be present. You, him, Mr. Hartnett, myself, the staff, or certainly any members of the public who might be inclined to appear at the hearing. So, Mr. Hart, do you have anything you want to say at this point before I make a decision about the potential continuance?
No, Your Honor.
Okay. I'm satisfied that reason exists to continue this hearing because the medical reasons related to Mr. Castro's health. I am making this decision also with the requirement that when Mr. Jacobs, that when your client obtains written confirmation from his medical health provider, that a copy of that be provided to us. That will be will not be something that will be, because it relates to his medical care and treatment, not be something that's made public, but I want to see it. So I'm sorry, go ahead.
Should that be submitted the routine way or just by email to Ms. Zhao? How do you want me to do that?
I'll have to ask her. She's really the boss. I'm just a figurehead.
Yes, if you could email it to the post C review email that we've been corresponding through, and include Attorney Hartnett in that correspondence as well.
I will, thank you.
All right, and having said this, obviously all parties are instructed not to share that outside their their staff, etc. Okay. And having said that, we need to find a new hearing date. I want this time for us to set a 3-day period. Turns out, now that I've seen the number of exhibits, the number of proposed witnesses, and the other issues we discussed at prior status conference, it's apparent to me that this is not something that can be accomplished necessarily in 2 days. I'm hoping it can be accomplished in 3 days. Our schedule also should make provision for the appearance of witnesses such as law enforcement personnel that that we do not want to have to be sitting around a conference, the civil service room for a day or more, or hours, not be able to attend to their duties to appear by Zoom. Presumably they're going to do so at the office of the city attorney, as we were discussing before, and I understand nobody has objection to that. Is that correct?
I have no objections wherever the hearing can be held, Your Honor. Whatever is convenient to you and to the division, we will go wherever.
All right. Well, we talked the other day about some witnesses that necessarily will appear both because of request of counsel and my own requirement that certain witnesses appear in person. For instance, the respondent who would be present anyway. I understand that the mayor will, if he's still a witness, will appear in person. I think there were some others we discussed at the time. Right now, I'm not at my office, so I don't have my list in front of me. Weren't there others, Mr. Hartnett, we were talking about being in person?
There were four witnesses for the division, plus I believe Mr. Mayor DePina and Mr. Spanner and the respondent were going to be in person, and the rest were being established by Zoom, is my understanding.
All right. And the 4 in-persons were?
That would
Those
be,
are
Wait a second.
sorry,
Go
that would
ahead.
be, yeah, those would be my witnesses, Your Honor. That'd be Lieutenant Rossi, Sergeant Dar, Captain Montas, and Captain Guerrero.
Okay. Just so it's clear on the record. Thank you. All right, is this something we can do I'm just getting my calendar. Is there something we can do now? Or are we going to have to get information, Lizzie, for instance, about the availability of the civil service hearing room?
Yeah, so I will have to get availability from the Civil Service Commission. And if we do need an interpreter, they do require some notice to be able to book someone. So they said at least 2 weeks notice is preferred.
Looking at my calendar and having discussed all this with you folks before, I'm confident we're not going to find a date in less than 2 weeks, a 3-day period in less than 2 weeks from now to hold this. So I think we'll have plenty of time to put everybody on notice. I'm sure, and I'm looking at my calendar and I don't know. I think I'd rather start with you folks telling me when you think you could do it.
I have this December 8, 9, 10, and 11 open, no hearings or anything else. Any of those days are certainly open, available without any conflicts at all. And that should give sufficient time if I notify Mr. Houghton for him to be able to arrange to see which days all of the witnesses for the city, the police officers can appear. Mayor DePina should be back from his trip out of the country, and everyone should be, Mr. Spanner should be recovered and well, so that we should be able to do that, I would think, with that amount of lead time. But we're flexible as well.
Okay, Mr. Hartnett, how did the 8th is a problem for me. Does the 9th, 10th, and 11th work for you, Mr. Hartnett?
Those are the days I was thinking. So those are great.
Well, it's a miracle. It's unbelievable. And then
We try.
yeah, I'm impressed. I'm probably going to learn from somebody else does that work as far as we're concerned, Lizzie, assuming the availability of the room and an interpreter?
Yeah, that should be fine. So we're looking at December 9th through 11th, just
Yes.
confirming. Okay. Yeah, that should be fine.
Okay. Let's keep our fingers crossed that there isn't some hidden conflict and all out there, but that sounds good to me, and it's a relatively short continuance in terms of on a broader scale of things that could happen in the routine. So let's plan on that. If there's any issues that come up between now and then, you know how to contact us, and we can hold a conference if necessary. There were some last minute scurrying around issues that came up that I know I addressed as well. I saw some emails come in. Did we end up sending out that proposed the response I had written, Lizzie? I don't know if we got around to it with everything else that happened.
Yes, we sent that out this morning.
All right.
to the
So
parties.
again, I probably have that somewhere here in front of me, but after receiving my response to some questions raised, are there any lingering issues?
There
No.
were there are, you, I think, addressed the issues of redaction, Your Honor, that those would be addressed at the hearing. I think Mr. Hartnett and I will continue to communicate. We may not have a problem. We may just use verbal testimony and not worry about the documents being redacted. We may be able to accomplish everything we need to accomplish that way.
All right. So what we need to do, though, this is what I was trying to convey earlier. If there's a particular part of a witness's testimony that warrants confidentiality, I'm just trying to make this easier quite frankly, for our staff to be able to be prepared to do that during the course of a hearing and not cause major disruption. Remember, we talked about doing it perhaps at the close of a witness's testimony, the last bit, and maybe the beginning of a cross-examination if it were coming out on direct in the first instance. Does that still seem workable?
Yes, Your Honor.
I think
Are you following me? I don't know if I'm being very clear.
yes, Your Honor. If it's one of Mr. Hartnett's witnesses, I think what we had decided, he would leave certain things toward the end of his direct, and then it would close and my cross would be closed. If I'm going to do something with a witness on my direct, I will certainly prior inform Your Honor, before I ask questions. I will certainly do my utmost not to go running full steam ahead into something that we might, or you might want to consider closing.
You'll have to do more than do your utmost.
I will succeed in accomplishing it, Ron.
Yeah, no, this is not a good, you don't get a star for good effort. We really need it for keeping close. If there's, there's limited instances where you want to, where it's permissible to close any portion of these proceedings. So I want to make sure we're careful about that, both protective of the interests of the witness and the right of the public to be informed. So what I would suggest is that you identify for us, excuse me, the particular witness that is likely, or witnesses that's likely to involve, so at least we can be prepared to, ahead of time to close that small portion of their testimony.
Your
We
Honor,
will do that, Your Honor.
Your Honor, I just so I think this is all. I think this is all in my motion. I think I've named there's two issues. One, there's the medical issue, and I've listed the two individuals who may testify about that.
Okay.
I think, I think that's fully addressed. I think everybody's in agreement on that. And then there was just a limited about information about a third party who was not a witness to this case, and that's where there was personal information and then personnel information. And I think there was total agreement on the personal information, the home address and whatnot being redacted from a document, and there's no reason for it to come up in the hearing. And then I think there may have been some misunderstanding as to the scope of what I meant by personnel information. I've tried to express both in hearing and in phone calls to Attorney Jacobs that I'm really just talking about essentially just the employment status of that individual, which I think should be protected. And I've redacted that information. That information was redacted. I gave Attorney Jacobs a copy of the redaction, a chance to say whether or not I thought we were in agreement about putting it in and giving it to Ms. Zhao, which I did. And so unless there's a problem with that particular, that very limited information being redacted, I don't know why it would necessarily need to come up even in oral testimony either. So it's not everything about this individual's personnel record. It's a very limited scope. I mean, I understand there's some of that stuff is fair game. So.
Are you in agreement, Mr. Jacobs?
No, Your Honor. I understand what Mr. Hartnett has said. I will have some further discussions with him prior to the hearing. We believe that some of that personnel information that he may believe is not relevant is relevant based on a cross-examination of a witness, because we believe that there are issues motivating certain witnesses to say certain things and do certain
But right
things.
now, hold on. I'm less concerned about relevance than I am right now than I am about public disclosure, which is what I thought we were talking about in terms of a redaction. If it's necessary that I can decide relevance at the time I see what you're talking about and make a ruling on it, it's just a matter of whether this is something that is a matter that's available to the public. Why do you have any objection as long as the information is provided to me, the fact finder, that particular limited piece of information be disclosed or kept confidential?
Oh, I have no problem at all with any, and this is what I thought we had agreed. I have no problem with Mr. Hartnett's redactions to the public of personnel type information, as long as Your Honor has it available and as long as I can cross-examine, subject obviously to Your Honor's relevance and other rulings. I don't want a lot of the things I'm going to cross. I'm not asking for this to become necessarily public knowledge, but I think I have a right and representation to bring it forward before Your Honor,
Right.
for Your Honor's
So,
consideration of the facts.
So do you have a problem, Mr. Hartnett, with that limited information being redacted but available to me as a fact finder?
No, Your Honor, that's exactly what I'm asking for.
I didn't think so. I mean, that's why was confused by the concern here. So
yeah,
if you're going to question about, but that's the third witness, that if it's not just a matter of being in a document, if it's your intention to question about it, we need to be forewarned so we can close that limited period of questioning presumably by Mr. Jacobs on cross, to keep that confidential and closed. So I know who the other two you're talking about, Mr. Hartnett, are. I remember from the motion, but I'm not sure right now if that person's name was even mentioned in your motion or not.
So that person's not anticipated to be a witness. I suspect, and I don't know, that he may come up with one of the respondent's witnesses. I mean, I can make my guesses as to who it would be, but that's up to him, or it may not come up at all. I don't know. And I think I do think we could probably just address, if that happens, we could address it at the time. I don't think it's going to be an issue. I'm not concerned about that.
Okay, but person about whom these records relate is not somebody you intend on calling.
Correct.
And is it somebody at this point that you intend on calling, Mr. Jacobs?
I'm not 100% sure we're talking the same person, so I'll have to talk to Mr. Hartnett offline,
right, why don't you
just to
two
make
talk
sure we're
about it?
not in confusion.
Okay. It's clear to me. I don't think there's any objection as to the redactions here. It doesn't foreclose the information from being attempted to be used in cross-examination or in some other way as part of the defense, as long as it remains confidential. And as long as it's subject to any objection for relevancy or any other reason that it might be objected. But I just want, it's easier for us to monitor this and control it if we're aware of during which witness's testimony it might come up, that kind of thing. So that's what I sort of want you to alert us to before the actual hearing.
Understood, Your Honor.
Okay, is everybody all right with that?
Yes, Your Honor.
Yes,
right.
Your Honor.
Are there, I don't know which one of this incredibly stellar staff just sent me the email that we were talking about. Thank you, whoever did it. I'm looking at the other issues that were raised. I don't know, as long as you got this email and you've mentioned the one issue you wanted to talk about, I think the other responses to some of your questions are pretty obvious. Are you any confusion about any of them? This was in email sent from post review today at 10:13 a.m.
No further. I don't have any other questions, Your Honor.
All right. Anything from Mr. Jacobs?
I don't believe so, Your Honor. Thank you.
All right. All right. If there's nothing further, we'll adjourn this conference and we'll see you on December 9.
Thank you, Your Honor. Thank you, Ms. Zhao. Starting it.
Thank you.
Thank you.
And I'm sorry. Did you hang up? We lost him.
Yeah.
Okay. Well, I already told him that I wanted a copy of the medical healthcare provider, so that's fine. Thank you all.
Thank you.
Bye.